Chairman Poland, Commissioner Kohler, Commissioner Goldberg, Commissioner Lukacs, Commissioner Popkin. Chairman, you have a quorum.
Thank you, Mr. Chairman. The only thing I wanted to add is we still, the Bond Farm project is still, we've closed public hearing, but it's still active. So no excommunication things are allowed. So not that we got a big crowd behind us, but just want to remind everybody. And that is all I have.
My address is 328 Grant Street in Longmont, Colorado. I am reporting on the progress that has been made since the June 21st public planning and zoning meeting regarding the site plan for the Bond Farm development at 1313 Spruce Avenue. At that meeting, commissioners,
It is starting to sound like that, Mr. Chairman. If there's a comment about the process, that would be appropriate, but not about the subject matter itself.
this is a report to share what has taken place between neighbors and the developer, between the last planning and zoning meeting and now.
If anything mentioned about the plan, that would be where we'd have a trouble.
Yeah, it's just basically saying what we've arranged, and
I think that'd be good.
Yeah, that's fine. Okay.
yeah, it's arrangements that, I mean, just showing that we're cooperating. Okay, that's all.
Oh, yeah.
We just have to make sure.
I mean, that's basically what it is, but it's 4 minutes, so. I'll just start over. I am reporting on the progress that has been made since the June 21st public planning and zoning meeting regarding the site plan for the Bond Farm development at 1313 Spruce Avenue. At that meeting, commissioners had recommended that developers of the 1313 Spruce Avenue property, Mark Young and Dan Williams, reconsider their approach to the neighborhood compatibility of their current proposal. Commissioners voted 7-0 to table approval of the concept. Mark chose the October 18th public planning and zoning meeting to re-present his concept. It was recommended but not required that Mark work with the neighbors in a charrette process to bring the sense of compatibility to his concept. We understand the primary concerns from the commissioners pertain to the compatibility of the proposed plan's massing. What's clear is that the definition of compatibility remains ambiguous and vague. The developers contacted us after the June planning and zoning meeting to plan how to move forward together. We created a series of events with an end product where all stakeholders would compromise to a degree, but with an end result that considers new ways to look at the site plan and defining compatibility. Those planned events are as follows. 1, host a mini charrette to define compatibility moderated by Brian Dunbar of the Institute for the Built Environment on July 28th. 2, engage in efforts to rethink the site plan and massing by professional designers outside of Mark's team. 3, host an architectural design charrette moderated by Brian Dunbar of the Institute for the Built Environment on August 18th and 19th. As part of the effort to rethink the site plan and massing by professionals outside of Mark's team, the developer met with Michael Tavel, AIA, design consultant, chosen by neighbors, who also attended the April 28th Visionary Charrette. The developers held this meeting on July 18th to include their civil engineer Jim Allen in an effort to explore possible solutions for a workable and acceptable site plan. The goal of the meeting was to transfer the current site plan and all drawing files from the developer to the desktop of Michael Tavel and to ask any clarifying questions so that Michael could successfully look at the site from a different perspective. A little about designer Michael Tavel. He is a member of the Institute of Architects, the principal of Sun Studio in Denver with a long list of award-winning design projects. His firm specializes in sustainable urban neighborhoods, providing full-spectrum design and planning services. His recent project is Lafayette's Silo neighborhood, an intelligently planned urban mixed-use community that complements and retains the rural appeal of Lafayette. In other words, a model sustainable neighborhood. The July 28th mini charrette to define compatibility will include interested members of the community, outside professionals, city staff, and the developer team. The August 18th and 19th architectural design charrette will be a larger group charrette to specifically address architectural and design elements, incorporating the concepts of compatibility from the mini charrette. We anticipate presenting the findings of the more in-depth charrette at the future Public Planning and Zoning meeting, which will hopefully guide you in your final recommendation to the City Council. Rest assured it will be based on all available input from the neighbors as well as experts. Our goal is to include all concerned parties. In short, we are opening the door to all concerned parties, and it will remain open. We trust that all interests will walk through the door so that their voice will be heard. Thank you for your time.
Perfect. Thank you, Jane. Okay, I think this is better. Okay, would anybody else like to come forward to speak on items not before us today, or items that are not scheduled to come before us that are quasi-judicial? You're free to come forward. Seeing nobody coming forward, I'll go ahead and close the public invited to be heard. There are no minutes to approve. There are no public hearing items to approve. We'll move to other business. A request to amend time of postponed meeting for 1313 Spruce Avenue from October 18th to August 23rd, 2023. And I believe that we have Planning and Development Services Jennifer Hewitt Apperson to come forward for this.
Good evening, members of the commission. This evening, we do have a request from the applicants for 1313 Spruce Avenue's concept plan amendment to revise the extension date from the previous meeting, so from the June meeting. Was it June? May? June. It's like, when was that meeting? So from the previous meeting to where the public hearing was continued essentially to the October meeting. There's a request from the applicant to move that up into the August 23rd meeting, so the fourth Wednesday in August. There's a request by them to move that up, and with that, I don't really have anything to add. The applicant is here and they can discuss that request further, but it's pretty straightforward.
Okay. And Glenn, I believe that this is a two-stage vote that we have to take, correct? Can you explain that to us?
Sure, I've got Jeremy's memo right here. So your first motion would be to move to reconsider the commission's June 21, 2023 vote to continue 1313 Spruce Concept Plan Amendment hearing to change the date of the hearing. If seconded, the motion to reconsider the decision may proceed to discussion and vote. So that's part one.
Okay. And then part two is setting the new date.
Correct.
Okay. Is there any discussion, any comments, questions from the commission, any motions? Just a second here. Commissioner Popkin.
Yeah, just a point of clarification on the process here. Before, do we have to make the first motion there to even consider the topic as
Yes.
presented? Great. Well, then I will move to reconsider the previous question.
Okay, we have a motion to reconsider. Do we have a second? And it has to be a second from somebody who was at that meeting. Commissioner Lukash?
I second.
We have a motion, we have a second. Any questions? If not, let's take our vote.
Sorry, Commissioner Kohler? Aye. Commissioner Goldberg?
Yes.
Chairman Poland?
Yes.
Commissioner Lukacs? Aye. Commissioner Popkin? Chairman, that passes 5-0.
Okay, we're past the first step. The next one is reconsidering the motion, setting a date certain for it, and they have asked for the August 23rd, 2023 meeting. That would be after the charrette. Do we have any questions, comments, motions? Commissioner Goldberg?
Yeah, thanks, Chairman. I think in our email from staff, there was kind of the note or the statement that if we adjust the dates, that the applicant is still bound to the criteria like notification of the neighborhood and things like that. I wonder if it's worth asking the applicant, and is now an appropriate time to ask the applicant to come up and just give us the 1-2. I'd like to hear from him if kind of how we got in this position, and just to hear why we're confident that August works. Is this fine?
Yep.
Cool.
Thank you. So we had done a lot of work in advance. And when we made the presentation for the concept, for the concept plan, we had it stripped down as tight as we could to be efficient, and I called it the great simplification. So, the thing that we were struggling with the whole time, I think you were struggling with it too, was what in the heck does compatible mean? And so, we've got this early charrette coming up where we are specifically just defining compatible. And so we're gonna have a punch list, this, what kind of setbacks you have to have, what kind of transparency you gotta have, all the different things, a lot of which are already in the code in 1501, I think it is, the residential development code. But we're gonna see how we can apply that with the neighbors. We've invited what they call the No Longmont group and the Yes Longmont group and the other Longmont group, and then a bunch of professionals. And so we're gonna sit around, we're gonna come up with the definition of compatible with some line items that you guys are gonna be able to look at, assume you agree, and say, yep, that it meets that standard, that standard, that standard. Then we're gonna design to that standard. So, and we hope that it's a good meeting of the minds. And we hope, quite frankly, that it's something that Longmont can embrace going forward, because other developers like me, who, don't want to throw darts in the dark, can't, really tell. I just didn't know what to do. So anyway, that's why we have the first charrette plan. The second charrette is more architectural. And we're not really looking at architecture right now, right? But it's going to inform the massing study. So we think we'll be ready, and we think we'll have, I'll never have a consensus of the neighbors, right? Even if I convert 30% of each group, there's still going to be a vocal group. So we're just going to have to learn to compromise and get along. I guess in my world, that's kind of what compatibility means. So I think we're ready, and that's why we'd like to do it.
And Mark, you don't have a problem with the mailing out
Oh, no.
notices?
Oh, no. We've timed it to a T. We've got it figured
Okay.
out. We wouldn't ask.
I was just gonna say, it's August 9th would be the deadline for posting and mailings, which is more than more than reasonable for us.
Okay, very good.
Great. Any other questions?
Commissioner Goldberg, or are you done?
I think you covered it, Chairman.
Okay, thank you.
Thank you.
Commissioner Kohler.
I'm not sure who could answer this. Was there notification of this hearing to the public?
No, this isn't a public hearing,
Okay.
so we weren't bound by the same mailing and posting of the site. We did reach out to several of the leaders in the neighborhood and let them know what was going on,
Okay.
so.
And you haven't received any feedback of their concerns about the change of the hearing?
Just a few questions we received today about the process going forward, so pretty much what was explained here, that if you do approve that date, we would be doing, we intend to get the new plan, if there is one, on August 9th, and we would do the mailing shortly after that. August 2nd. August 2nd.
And so the mailing has to go out before the results of the charrettes, correct?
From the second ones, yes.
And so I guess that's my next question for the applicant. It looks like the last charrette is the 18th, so you have 5 days to sort of get the results of that charrette back out to the community before the hearing? It seems tight.
Sorry, gosh. I understand it seems tight. What we're not presenting is detailed architectural drawings. What we're presenting is a concept plan saying, here's an RMN zone. This is how it's zoned. And here are the rules of compatibility that we'd like to have applied to this plan. And then, I don't want to design the project. I mean, that's for site review. That's not really for a concept plan. So we'll have, just like staff last time recommended approval with 2 conditions, this could have 12 conditions, to help define compatibility, if that makes sense. I'll just hang out up here if you guys have any other questions.
Okay, Commissioner Goldberg.
Thanks. Thanks, Mr. Young. Jennifer, just to make sure we have all parties aligned here, does this make sense to move this up by 2 months? Are we putting the applicant at a risky position not to be able to meet the deadlines or not being ready on time?
This request is being made by the applicant and is not staff initiated.
Sure.
So it is, the applicant is confident that they will not be up against the wall, so to speak, that they can meet the deadlines that we have expressed that they would need to meet. So that would be getting all plan materials for the packet to us by that first week in August in order to meet, and then having new notices posted by the 9th and posted and mailed by August 9th for this meeting. So they are aware of the deadlines and they're confident they can meet them.
And if they get you the information on the date that you said, I think it was the 2nd, that's plenty of time for your team to do what they need to get the signage up and out.
Correct, yeah.
Okay.
Okay, Commissioner Popkin.
Thank you, Chair. Question for the applicant. Mr. Young, welcome back. My question for you is actually building off of a comment of my fellow Commissioner Goldberg that he made over 5 hours into our previous meeting. And that was, I think he asked originally to you, he directed a question to you. And we can refer to the minutes or the video if we need to, but what was your preferred date? And I think at the time there was a consideration of a September meeting, and I think you actually initiated the October date as being your preference at the time. So I'm just curious if you could explain, for our purpose, for our understanding, for the understanding of the residents who are here and maybe watching this after, what really prompted this, maybe cutting this timeline in half?
Of course, there's financial concerns that caused me to do that. The biggest single element was a lack of understanding of what compatibility means. I didn't think, if I went all the way to October and came to you with a plan, I have no idea whether your interpretation of it's gonna be compatible or not. What I can do is develop rules for compatibility that I think we can agree to, which will become conditions of the approval. I don't think, if I could, one of the plans we had was to come in here with like 6 or 8 different designs. Say, which one do you like? But that's not fair. That's not fair to you, nor is it really fair to me as a developer. And I don't even know if you could consider that and point at one and say, that's the one we like. So my sense of compatibility, your sense of compatibility, who knows if I could ever meet it. But if I develop a standard for compatibility, which I think we can do at our charrette, then that's something that staff can then look at later, right? We'll say, approved with these conditions. Staff will draw it up. Staff will say, yep, they did that. Yep, they met all the conditions. There you go. So and that kind of makes the transition from concept plan to site plan, right? Because that's really where these questions should be asked and answered. Concept plan is the wrong place to be looking at what this, these levels of details. It's okay to set rules. Does that make sense?
Yeah, I understand kind of your position on kind of when the place is to think about
Sure.
that. Let me see if I understand your position on the timing. It's that the extra those other 2 months wouldn't really change your approach at that point because you would have done all that you would have in the 2 months that you had. Is that
Yeah,
a fair
because-
synopsis of what you're suggesting?
It is, because I don't see myself preparing a detailed site plan to present to you guys to look at. I see us presenting to you a very basic bubble diagram concept plan and a consensus, hopefully, of the yeses and the nos, or the rights and the wrongs, or the goods and the bads, or the neighbors and the community. And, if it's really interesting, if you look at that, the residential development code, that 1501, I think it is, it talks about a lot of the things that we're gonna include in there, and so we'll be adding conditions to that. Conditions like setbacks, transparency, things like that. That'll then inform us as we go to the site plan stage.
Appreciate it, thank you. Quick question for you, Jeremy, actually. In the applicant's letter on page 2 there, I think it's the first full paragraph, the applicant states, "This has greatly impacted the applicant's development process and raised concerns regarding adequate due process regarding landowner property rights." Are you able to shed any light on what the applicant might be referring to, Jeremy, in terms of due process rights here? I mean, my understanding is the commission previously decided not to say no or yes to anything, just encouraged to, just pushed off the decision on that within a reasonable time frame that the applicant himself had actually stated. So I'm just curious if you have a sense of what that's referring to.
I can give my best kind of a guess
That's all I'm
and
asking for.
information. So I assume what the applicant is kind of hinting at is that Planning and Zoning Commission is a recommending body for the concept plan amendment application. And that a continuance by the Planning and Zoning Commission is not a final decision that's appealable to anyone. It's not a final decision in our land development code, it's not a final decision in terms of administrative review actions in circuit or district court. Now, the city council decision on the concept plan amendment would be a final decision that could be appealed to a court of competent jurisdiction. So if for some reason city council denied the application, the applicant could appeal it, and if city council approved the application, persons with standing as defined by our land development code could also appeal that decision. So I think that is what the applicant's referring to by adequate due process, is ensuring that they have a right to challenge the decision should it need to be challenged.
Appreciate it, Jeremy. And I think it's really important that we're considering how fair we are as a body to applicants, to developers. I also think it's only fair that we extend that same logic out to the community and to the residents who would be also affected by this. And so I guess a question either for Jennifer or maybe Glenn. One of the implications of this timing, I just want to acknowledge on the calendar here, is that this kind of hits it kind of right before the school year starts, kind of right at the tail end of kind of summer vacations. And while there's nothing in the code or bylaws that prohibits that. I just want to make sure that there isn't any precedent that's been set, again, given the fact that this is only like 6 months in for me, any precedent that's been set previously of like when we, if any schedules change, could there be a negative impact on people who were intending to voice support or opposition?
As far as I know, we haven't really looked that carefully at the calendar, as far as, possible conflicts. We did our best to kind of notify folks that this was coming forward. I haven't heard anything that said, oh, I gotta cancel my European trip or whatever it is. It's tough to do that. And I guess,
Sure.
I believe in speedy justice, I guess, so.
If I can add as well, I have not looked at the St. Vrain Valley school calendar, but I do know that the Thompson School District school year does start the previous week to the one requested, and they do typically run on the same start dates and end dates.
Cool. I'm not super concerned about that. I just want to make sure that we're thinking about any change to the timeline can change who can participate in the process. I'll reserve.
Commissioner Lukash.
Thank you, Chair. I have a question for Jeremy. So technically, this application came to us on June 21st, right? And we haven't seen the minutes yet. And until the minutes are approved, they're not official. Can we amend something that we haven't approved yet? Or is this the perfect time to amend something like this?
Thank you, Commissioner. I do believe it's still appropriate based on Robert's rules and our own bylaws. Our own bylaws allow for changing a continuance with the next 3 meetings after. And then with Robert's rules, the commission did make a decision at its meeting. Technically we should have the minutes probably ready, but I don't think the minutes not being finalized impacts the commission's ability to change that decision.
So since the minutes are not ready yet with this, assuming we're going to approve this, will that change the minutes?
No, the minutes will remain the same
Remain
for
the
the
same.
June, I believe it's 21st
21st.
Meeting. We would just reflect it in these minutes for the July 19th meeting, showing that the motion to reconsider passed, and then a motion to change the date, assuming it's made and seconded and voted on, was also passed.
Okay, thank you.
Commissioner Goldberg.
Yeah, thanks, Chairman. I'll just share my perspective with my peers here. We're at that part, right? Okay. Yeah, I guess, admittedly, I don't have any problem with changing the date. I think the onus is on the applicant, and while I have, general concerns or thoughts about this being pushed to, is it next month?
Yes.
Yeah, like in a few weeks. Admittedly, I kind of have my own feelings about that, but if the I think the burden falls on the applicant, and the applicant has done his due diligence, and his team is confident that they can execute and meet the deadlines that Jennifer's team has, and have, so at high level, I'm totally, I'm supportive of the request by the applicant. He's picked the original month and wants to change it, and I'm fine with bumping it back a couple months. That said, after we finish this discussion, I do think some of the comments, maybe that I've read in the paper and maybe in the applicant's letter, did raise some questions that I think we as a commission and staff could discuss. How are we informing compatibility and defining compatibility, and just some kind of maybe work to be done from our side. But for the issue in front of us, I'd be supportive of changing the date.
Okay. Do we have anybody willing to make a motion? Commissioner Goldberg?
I guess if no one's turning on their light and calling me crazy, then I guess I'll go ahead and, let's see, where is it? Let's see, if the motion to reconsider is approved, then I'll look to move to change the date of the continued 1313 Spruce Concept Plan Amendment hearing from October 18th of this year to August 23rd.
We have a motion. Commissioner Popkin?
Given that the community and residents have also been a part of this process, I will I will second the motion.
Okay, we have a motion, we have a second. If anybody have any questions, comments? If not, Jane, we are ready for a vote.
Commissioner Kohler. Commissioner Goldberg. Chairman Poland.
Aye.
Commissioner Lukacs. Commissioner Popkin. Chairman, that passes 5-0.
Thank you very much. Thank you to the applicant, thank you to staff, and thank you to the public for being here. We'll move to the next item, which is public invited to be heard, final call. This is for, once again, items that are not on the that was not on the docket today, and items that are not quasi-judicial and scheduled to come before us. If you, I think from what we've kind of done here earlier, if it's a comment about the process, we will allow that, but that's kind of where I think we're going to try to draw the line for this. So if anybody has a comment from the public, please come forward. Once again, state your name and address for the record.
Hello. I'm John Lochran, 220 Sherman Street. I always seem to have something to say. Sorry. Anyway, I just wanted to talk about the charrette process that has been brought forward here. And during the previous hearing, some of the commissioners suggested that the charrette process continue with the developer and the neighbors. And they, several, I'm not sure, one or a couple of the commissioners mentioned that they had been unfamiliar with that process. Myself, I was unfamiliar with it as well until I was thrown into it when we did that. You've heard you heard a discussion about all these charrettes that are lined up, and I would just say that the core group of I would say generally the core group of the neighbors who signed a petition and have been very outspoken are not very convinced of the efficacy of the charrette process. And I believe that having looked over some of the description of the process, it seems like it's not a vote. It's not something that people vote on, yes, this feature or that feature or this density or that. It's sort of a design thing where people put together designs. And even the previous charrette that we had done, there was a criticism from someone who was an architect who had said that there wasn't a lot of design going on there. In fact, the one group that I was in was we put up a design on the wall. The other ones were comments about parking or something like that. But it wasn't carried out as it was initially, perhaps in theory, meant to be. And I've been in conversations with Brian Dunbar from CSU as well. And I just feel that, a number of the neighbors have those reservations. And the big reservation is when you have this division of, we're going to have 4 people pro-development, 4 people against the development. And again, we are more just trying to get it to be compatible with the neighborhood. We're not opposed to the development. But the other group, for example, Mr. Young mentioned Colorado Yes. I mean, they have campaigns out that say YIMBY, yes in my backyard. That's their whatever, their philosophy, or that's their goal. In the first charrette, in a way, just as a devil's advocate, I asked the question, are we going to be debating like pro-housing, density or against that today? And I had an interaction with Mr. Young. He said he'd be happy to debate me, but that's not what we're doing. So I'm not sure where these other charrettes going to define compatibility. And I would just close with, like, if I was going to ask someone in here to pick out a tie for me today, right? That wouldn't be something that would be done in the abstract with a definition. And I've been looking up definitions of compatibility, and you know pretty much what they are, or synonyms. But if I was going to ask you to pick out a compatible tie for my shirt, you would start right here, looking at me and the surrounding neighborhood. So I don't know that the outside groups are what's called for, based on your charge to address density and massing in regards to compatibility. So I don't know that the charade thing is going in another direction. And we're not all on board with it. We've been having a lot of conversations about setting up another meeting with the developers, and we've had some movement on that perhaps. But, you know, I didn't want to disparage the charrette by saying it was a charade, but that was part of my feeling of it at that point, that it wasn't really what was required in this situation. But anyway, thank you for listening.
Thank you, Mr. Lochran. And seeing no one else come forward, I will go ahead and close out the final call, public invited to be heard. Next is items from the commission. Commissioner Goldberg.
Yeah, thanks, Chairman. I think if I'm allowed to, I'll maybe ask Jennifer and Glenn, maybe and Jeremy to weigh in here. You know, following the last hearing, there was an article in the paper highlighting just a local story about our meeting, our long meeting. But I think in that paper, the applicant or someone representing the applicant said something along the lines of like, design or compatibility is like throwing darts at night or something, or in the black or without the lights on. And I appreciate Commissioner Popkin referencing the applicant's letter. The letter says that there's a lack of understanding of what is compatible. They cite without clear, specific, adopted guidelines. You know, so there's this kind of recurring theme, at least from the applicant. I don't know if it's come up too many times in previous projects before us, but seems to be this perspective that maybe we're not giving the applicants enough guidance or a clear definition on what is compatibility. And I wonder if maybe each of you can kind of weigh in on what's your thought on that? Are we providing enough guidance on what compatibility is? Does that fall under our purview? Is that staff's job to define what compatibility is? Are we failing the applicants to some degree by not giving them more direction? So could we just talk about that as a group real quick? You know, what are your thoughts on compatibility, and are we setting people up for failure or throwing darts at night?
I'll take a first stab at this. I've been a professional planner for a very long time, and across in other places in the country as well. And I think it's not uncommon that compatibility doesn't have a neat definition of here are 6 criteria. If you meet 4 of them, you're compatible. If you don't, you're not. It's intentionally subjective. It's because of all of the planning principles, compatibility is probably the biggest, well, it depends out there. So, and that's really where we as professional planners, you as planning commissioners come in. You know, I think if, you know, the applicant, if someone were proposing a 6-story building adjacent to single family, you know, that was 1 or 2 stories, clearly that's not compatible. But when you're looking at, you know, different densities that, you know, may be different from what's existing, but it's maybe not that far off, or, you know, the uses are similar, but the scale might be a little different, you know, that's where you really kind of get into that nuance of debate. And so, you know, as part of that, what is compatible? Is it compatible? It's left up to us quite often to use our professional judgment and determine, okay, we think maybe there could be some challenges here, but here are some steps we could take to mitigate that. Here's what we can do. You know, we can use things such as landscaping. We can use things such as building design, and buffers to get there. But like I said, it's a giant it depends on what is compatible. And with that, I'm going to let my colleagues weigh in if they have anything else to add.
It is a good question. We do have a very specific definition of neighborhood compatibility, and there are standards that you have to meet in order to meet those. But then with a concept plan, it's just kind of wide open. So I think the code does give some guidance. I went through and read Envision Longmont again, and it does speak to scale. That's the only other word, and maybe that's in the eye of the beholder too. I think it comes down to is that's why we have a planning commission with 7 great commissioners to reach a consensus of what that means in this specific situation.
Jeremy?
I can add in some of my perspective from a legal perspective. So looking at one of the sentences in our bylaws, this is under section 8, voting. It is understood that each member of the commission, has an opinion concerning the proper development of Longmont. So that speaks sort of towards our democratic process of having citizen commissions helping to regulate development within the city. From a legal perspective, part of when I talk about due process in regards to Commissioner Popkins' question, the Constitution of the State of Colorado, United States, requires that land use conditions imposed by a regulatory board or agency, which also includes subdivisions of state, including the city of Longmont, must be sufficient to ensure that there's a rational and consistent basis for the decision and judicial review of that action is available. Numerous courts have looked at compatibility and noted the broad criteria of compatibility surrounding areas, harmony with the character of neighborhood, when applied in conjunction with other specific criteria, satisfies that specificity requirement. So if you look at our major development criteria, we have a lot of different criteria that is more subjective. Does it meet A, B, and C? Compatibility talks about, I'll read from our land use code. Land use, site, and building layout, design, and access. So those are specific criteria that even when we're looking at compatibility, those are things to focus on. And so given that and given our existing case law, certainly our compatibility standard is constitutional and allowed. The only other thing I can provide to the commission, we don't have a clear definition of compatibility for all the reasons we've talked about, is that part of it is the citizen process. Certainly the commission's free to look at other portions of our code. So there's a section on beneficial taking, and the hearing officer, if that ever happens, may have to consider compatibility of the neighborhood. And just for example, our code gives the following criteria to consider for compatibility: architectural character, building size, height, bulk, mass, and scale, building orientation, privacy considerations in terms of privacy prospective residents, and in terms of privacy protection for adjoining land uses, building materials, building color, and then also the development project itself, if it's residential, commercial, things like that. I don't think that really applies to this concept plan for a lot of those conditions, but that goes back to that land use and what's in our current criteria we're considering. So is it a moving target? Perhaps, but it's based on certain criteria and it's part of our beautiful democracy.
Do you think any of our neighboring municipalities might have a better definition of compatibility, or are they able to better guide their applicants, or is this just kind of, this goes with being a developer, is they need to kind of have their vision for how their project fits in, and then staff needs to review and make their recommendations, and then ultimately it comes to us for the final go, no, or penultimate go, no go.
I think I'll just echo what Jennifer said. I mean, I've worked for a number of communities too. I think actually we probably have a lot more in our code as far as gets to what compatibility means.
Okay. I think what we learned in our last meeting is that the applicant checked a lot of the boxes. Like high level, there wasn't, like, I don't think the applicant, I want to be mindful here. There wasn't any really red flags from the staff perspective, actually, at least to the degree that we were reviewing the project. I think maybe what we all agreed on was, or one glaring red flag was around the massing and just the scale of those structures and how it impacted the neighbors. And so I guess I'm not sure exactly what I'm trying to say, except for, I heard the applicant on multiple occasions express concerns that they feel like they don't have enough direction. I think what I'm hearing from staff is we're providing enough direction. We provide kind of the appropriate direction. We probably follow standards that other municipalities follow as far as what's included in our code and what's included in our comp plan, and kind of help give the definition or the kind of the guidance, the overarching guidance on where we see Longmont going. But ultimately, compatibility can't be certainly defined, and so it's going to be a little bit on the developer, a little bit on staff, and then it sounds like a lot on commission and council to make the final word. Yeah, okay, that's helpful. Harmony, character, size, height, bulk, and scale. I'm looking at the applicant in the audience, and I just think, I know you've had frustrations and you're wanting to bring 6 options to us or have, clear direction on what is compatible. I think in the end, the onus is gonna fall on you or any other applicant that comes to us in the future. And then hopefully by the time you get back in front of us, we're able to feel comfortable with it. And we very often do. So this was a unique case for us.
Commissioner Popkin.
Thank you, Chair. I just want to build a little bit carefully on the train of thought of my fellow commissioner. It's context that matters, and I think that's kind of what you were trying to get at there. And what happens in one, and I just there were statements made today that I don't think necessarily are uniform. One neighborhood is different from its adjacent neighborhood, and that's part of why there are different classifications in Envision Longmont. It's part of why we look at different concept, design, site criteria. That's why staff is so diligent and meticulous in reviewing all different types and angles of the 6 to myriad definitions and considerations that Jeremy and Glenn and Jennifer, you guys were just describing. So, a single family house going up to a 6-story building, going up to a 200-story building could work in New York City, right? And so it's all context and location and situation that can matter. And you in fact have that in New York City, right? And it's just because there's it's a different plan, it's a different expectation there. And so I think what I wanted to really say is, in addition to context matters, all 6 of the design review criteria still matter for when we go forward, and they always do for all of our considerations. And I don't want to put one over the other. I think many of them are self-explanatory here, but or less subjective, I should say. Obviously, the compatibility one was rightfully highlighted as being one of the areas where there's a little bit more subjectivity involved, and where there are multiple layers of commentary and decision making that have to come in an advisory standpoint here. But then number 4 is also gets to that as well, right? And the application will not adversely affect surrounding properties, the natural environment, existing or planned city transportation or utility services or facilities, or the adverse impacts of the use will be mitigated to the maximum extent feasible. What defines maximum extent feasible? I mean, there's a level of subjectivity that comes into play there too. And so my encouragement for anyone who is involved in weighing into this process going forward is that we consider all of the design review criteria, and frankly that I don't lose my train of thought mid-sentence, that when trying to get context for some of the comments that have been made in the past on the record as part of the quasi-judicial process, we look at all of the comments that were made, right? Unfortunately, you have over 2 hours of this body's deliberations to think about, and I would encourage you to consider all 2+ hours of that. Thank you.
Okay. Seeing nobody else from the commission, next item is items from Planning Director Glenn Van Nibwegen.
I don't have anything, Mr. Chair.
Well, we have 1 or 2 meetings in August.
I believe we're at 1.
Which is not
the 16th, right? Yeah, but does Kristen have anything, do you know? I think.
to be okay. I think we're good with that. And then seeing nothing else, we are in adjournment.